Hello, I'm Eddie Farah, and welcome to The Legal View. With us today is Mr. Bruce Feiffer, who is in charge of the Workers' Compensation Department at Farah Farah. Bruce, a common question we receive here at Farah Farah when people are injured on the job is whether or not they're entitled to a second opinion from a different doctor. As we know, a lot of times employees are sent to a particular doctor by their employer, and they're not really satisfied with the treatment or the opinion of that doctor. Does an injured worker have a right to a second opinion?
Well, the answer to that, Eddie, is yes, they're entitled to another doctor's opinion. It wouldn't be a second opinion. What it's called under the work comp statute is a transfer of care. It occurs one time during the course of the case, and the currently authorized doctor would be deauthorized, and then a new doctor appointed by the insurance company would be authorized to go ahead and treat the client.
What if that second doctor has a different opinion than the first doctor, and the patient indicates that the second doctor's opinion is more in line with his medical treatment? What happens at that point?
Hopefully the insurance company would just honor the opinion of the second doctor. However, in certain situations they may not, and that may lead ultimately to some further litigation that would have to ensue before the judge of compensation claims.
So a judge would make a decision as to which doctor's opinion prevails, is that correct?
That is correct.
What if the second doctor that the patient sees confirms what the first doctor says, and the injured worker then wants another opinion? Does he have any recourse at that point?
He could have a third opinion, which would have to be, in most circumstances, at his own expense. It's known as an IME, or an independent medical exam. And he would be able to pick that doctor, see that doctor, and if that doctor's opinion favors the injured worker's position, then it could be used in a hearing before a judge.
And what happened if the judge sides with the independent medical examination doctor who indicates that the patient is injured and needs certain types of treatment? Is the patient then reimbursed for what he had to pay for that independent medical examination?
Correct. If the injured worker prevails at the hearing before the judge, then in those circumstances the cost of the IME will be reimbursed to the injured worker.
Do you have an idea as to typically what these independent medical examinations cost?
Typically anywhere between $1,000 to $2,000, plus potentially whatever the cost of any diagnostic studies that the doctor may require, such as MRIs or nerve conduction studies, if those need to be performed to clarify a diagnosis.
Okay. Bruce, thank you very much. That was very helpful. And thank you for watching The Legal View.